Good morning, everyone, and welcome to episode 2 of our Practicalities of Rentals and Sales series. I am Rowan Terry, the newest member of the TPN legal team. Our discussion today is about the unspoken code of tenant and landlord behaviour. And boy, is it an important one. No doubt you hear more bad stories about landlord-tenant relationships than good. And why is that? Mainly because bad news travels fast as well as wide. However, my experience within our industry tells me that we can fix this, but with all fixes, it takes some movement on both sides as well as expert advice. I believe that we need to work together and ensure better alignment, respect, joint compliance, and mutual objectives to end up at a win-win relationship. And joining us today to discuss this is Silna Steyn, Managing Director of SSLR Incorporated. Welcome, Silna.
Thanks, Rowan. It's so nice to be back in the stereo, especially with you guys.
Yes, yeah. Actually, a fun fact about Silna is that she was actually my principal when I was doing my article. So it's very fitting that she is my first guest speaker. So thank you for coming. It's good to work again together.
It's awesome. Thank you so much. And it's so nice to be with you. It's really cool.
Awesome. Thanks. And then we're also joined today by Albert van Wyk, entrepreneur, property investor, and best-selling author of the book Millionaire 22. He is dedicated to helping entrepreneurs and business owners across South Africa to reach their own financial success. Albert, thank you for joining us today.
It's great to be here. It's great to sit on the couch.
Good.
And have a chat
Welcome.
I think it's going to be very interesting.
Yes,
I'm looking forward to it.
It's going to be a good one. Last time I saw you, you only had one book on your mantelpiece, but you have since written another one. What is this one about?
This one is titled How to Buy Your Happiness.
Okay.
So it's all about finding the balance in this world of entrepreneurship. And Silna was actually an editor on the book as well.
Fantastic.
So she changed a lot of the stuff as well. But I think it's a great book. I think it's amazing to see what it has done for people that has read it.
Yes.
I mean, so many people read the book and they realized, hey, this is the key. Because the core concept of the book is basically, we are taught, go to school, go study, get the job, and then you'll be happy.
Yeah.
And then there's so many people out there that did everything right. They got the good grades, they went to study, they got the great job, and they find themselves on a daily position saying, hey, I'm not happy.
Yeah.
But I did everything right. And that's what this book is about, helping people to buy their happiness.
Fantastic. Well, a few of our viewers today will be winning a copy of your book as either the How to Buy Your Happiness or Millionaire 22. The winners from registering for this webinar will be announced just before our Q&A session at the end of the webinar. And a further 2 lucky viewers who complete the feedback form will be receiving copies of Albert's books as well. So make sure that you complete the forms at the end of the webinar. Winners will also be emailed and contacted for delivery. Welcome to everyone. Even a signature as well. That is fantastic. Well, welcome to everyone, and thank you for being here today. Just before we get into the training, just a few house rules. Please make sure that you are logged on to your YouTube account so that you can participate in our live chat. Send us all of your burning questions, which will be fed to us by Nikki, and will be answered by our panel during our Q&A session at the end of the webinar. If your screen is looking a little bit blurry, just click on the cog icon in the bottom right-hand corner of your screen and set your video quality to 720 or higher. And then, as I've said, we will have a 15-minute Q&A session at the end where a feedback form will also be posted. Please ensure you complete the feedback form and send it back to us in order to get your unverified CVP points, as well as a chance to win Albert's book. Great, then let's get started. So just with regards to landlord and tenant relationships, Albert, what benefits do you find arise from keeping good relationships with your tenants?
Well, obviously, if there's a good relationship, they pay rent.
Yes.
There's not a lot of fights. And I think a myth that's out there is a lot of property investors think there's always issues with tenants.
Yes.
That is not necessarily true. Over the last 10 years that I've been a property investor, I did a quick calculation this morning before the interview. I had about 304 tenants over the last 10 years. And I can count on maybe one hand or maybe 2 where I had really bad experiences with landlord-tenant relationships. The rest of the times, it's basically just a good relationship. But to get a good relationship, you have to have certain things in place. You have to be strict about certain things.
Absolutely.
And then you also have to be reasonable about certain things. And I think it's the landlord's responsibility to manage that relationship better.
Yes.
And I almost say I train my tenants by managing the relationship in a certain way.
Yes.
You can get a certain response from your tenants. And then obviously there's some tenants that just doesn't want to work together.
Yeah, obviously.
Just doesn't want to, be part of the team. And then you'll have to use other forms like a lease agreement or the law or some kind of legal tool to sort that relationship out.
Yes.
But I think if the relationship is managed in the correct way, then you don't have to go to all of the legal stuff.
Exactly.
You can sort a lot of the stuff out before going there.
Absolutely. I also think it's quite important to have a very comprehensive lease agreement that deals with all of these situations, which is exactly what TPN provides. TPN lease pack.
I actually use the TPN lease agreement.
There we go. Fantastic.
And especially the surety
Yes.
document that comes with that lease agreement. That has done wonders for me.
Fantastic.
Because sometimes your tenant doesn't want to play ball, right? And they're difficult and they don't want to pay or they do something wrong. But if you have a surety, which in my case is normally their dad or their mom or their aunt, or someone that they look up to and that they want that person to respect them. So when you call the dad or the mom and you say, hey, look, this guy is doing this.
Yes,
or this guy defaulted on his rent. And then the dad or the mom's like, but I paid him the rent. and then they call the tenant and within 5 minutes, that's sorted out.
Yes.
So by having the surety agreement with the lease agreement of TPN, you create that third party. That's nobody wants someone else to think bad of them. But sometimes tenants don't care about the landlord and what the landlord thinks. But they care about what their dad thinks, or what their mom thinks, or what some of the people even put their pastor on as the surety. They care what he thinks. About them. So
imagine you have to then actually go and collect the rent from the pastor, like, hello.
As sometimes it happened, right? They pay for the tenant.
Yeah.
And I think adding a third party, discussing the landlord-tenant relationship, adding a third party to this relationship.
Absolutely.
Kind of creates a stable environment for that relationship, because now there's a third person that also sees what's happening in this relationship.
Yes. Almost as an anchor. Stabilizing the relationship. So obviously trying to have a relationship with your tenant, you also have to balance the tenant's right to privacy. Silna, does a landlord have the right to invade a tenant's privacy? Because they're the owner of the property. So owners like to think that they can just kind of access the property whenever they want. How do you manage to balance this?
Oh, I'm so glad you asked this question, because this is one of the biggest questions I deal with, and it's usually exactly what we just talked about. Maintaining a good relationship as a landlord with the tenant is usually the basis of your rental joy. But the landlord that wants to constantly attend to the property, and I don't think it's that relevant in your context where you have multi-lets and multiple tenants in one property. Individual property. A family is renting a property and the landlord wants to constantly go and inspect. It's not an inspection. Even though it's your property, you are the owner of the property, it's important to realize that the right of ownership is a very complex right. So while you gave the right of occupation away to the tenant, in return for money, obviously, you can't attend to the premises constantly. You are only allowed to attend to the premises for the necessary inspections. And remember, the Rental Housing Act, in terms of residential property, only requires 2 inspections, your entry inspection and your exit inspection. Any other inspection cannot be done unless it is done on agreement between the parties. And so I'm a fan of a renewal inspection. Go and see if the property is in a good condition before you renew the agreement. But you can't constantly go to the property. I have seen owners that want to go to the property to maintain the garden and stuff like that. And I'm thinking, no, that's why we have a provision in the lease that says the tenant must maintain the garden. We can't just rock up there constantly.
Absolutely.
It's a very important thing, and that's usually one of the points where relationships break between landlords and tenants. Because the landlord is constantly there and the tenant is trying to, sleep in on a Sunday morning, and the landlord rocks up with his, tackies and lawnmower. It's like, hey, I'm just here to mow the lawn. That's not really how it works.
I used to do that, so no.
That's why I said not in your context.
When I was at university, I was studying, the whole week, and then the only time I was able to go and mow the lawn at my property, because at that stage I had one, a rental property, so I didn't have a maintenance team or whatever. I had to mow the lawn. So then the best time was a Saturday morning. So 8 o'clock, I rock up there.
And student accommodation.
And then I start. They partied Friday night. And now Saturday I'm there. But Silma, in my case, and maybe you can correct me on this, but in my case where I have properties that has multiple tenants on the property, in the lease agreement, I specify what they actually rent from me.
Yes.
So they rent the room. Yes. Or they rent the unit.
Yes.
And in that case, I specify in the contract that the kitchen, the living room, and the yard is communal area.
Yes.
And that makes it available for me to access at any time.
And not just available. The way your properties are structured, luckily I know what your portfolio looks like. I know exactly what your properties are like, but that's why I said yours is very different, because you're not just allowed to attend, you are required to maintain the common property. So you must be there the whole time. But you can't go and knock on the doors and be like, hey, I just want to see if you made your bed this morning.
So I can't go into the room, but I still have access
100%.
to the property, which is very good to have.
Yes.
Because then you can, I have rented out some of my properties to a family. And in this one occasion, they literally locked the gate. They had their dogs in the front yard on purpose so that I can literally not enter the property.
Yes.
And I didn't like that at all. So I prefer having, buy-to-let properties where there's at least 1 or 2 different tenants, so that I can access the common area. So maybe specifying in your lease agreement very specifically what the tenant actually rents from you.
I just want to interrupt you right here. Because the one message I don't want to go out is that landlords can attend to properties if they draft that into the lease agreement. So a multi-let is very different. But remember, I'm sorry, I'm just avoiding illegal access here. But it's important to keep in mind most of the properties that's being rented out by landlords is the full property. So you can't specify you are renting just a house and the rest is mine. It's actually a very good conversation. You can't say you're renting the house but not the garden. In the context of a multi-let, it's very different. And remember, you have house rules and things like that. But if you are renting a property to a family, they are renting the entire place, not just the house, not just that part. So the landlord can't attend to the property in any way. When it comes to those properties.
But like a lot of startup property investors that message me on Instagram or Facebook, is typically the guy that owns a property and he rents out a garden cottage.
Yes.
A cottage at the back of the yard. Or he kind of divided his house and he stays in his own house in the one half and then the other. And that's kind of the easiest way to start getting into property investment, by using your own house. To rent out a little garden flat or something. Yes. And I think in that case, the rule still counts that you can have access to the communal area, which is the yard or whatever.
Yes, exactly.
Great. So then,
sorry, we have a question from the audience. Some people are commenting on how many inspections they should do per year, and what best practice would be. It would be interesting to get your feedback. And it would also be, how long beforehand do they have to notify the tenant that they actually want to visit the property?
Yes, okay, so legally 2 inspections are required, and it is a must. You must do a joint entry inspection, so prior to occupation, landlord and tenant, or the agent on behalf of the landlord and the tenant must jointly inspect the property. And then your exit inspection must be done within 3 days prior to exit, prior to the impending end of the lease agreement. However, And this is about a mutually convenient time. So whenever the parties agree that that inspection must be done, just keep it in writing. Those are required. Now, in terms of the lease back, what we do is we do allow for the required inspections, so the entry and exit inspection, and any other agreed inspections. So what we recommend is, if you want to do a further inspection, record it in your special conditions. Say, for instance, you are a landlord or an agent and you are a little worried about this tenant. You feel like they might not maintain the property properly. Then already at inception of the lease agreement, record a special condition to say, at the end of month 3, we will arrange an inspection. Conclude it in the agreement, then it's perfectly fine.
Yeah.
The time period, the notice period, is a legal term. A reasonable time. So a reasonable time is very wide. I like to record it in a lease agreement to say, for instance, 24 hours notice or something like that. If you agree to 24 hours, then nobody has to guess what it is. But record it in the agreement, and you can't say, I want to inspect tomorrow, and the tenant didn't even see this coming. So if you don't have a specific agreed midterm inspection time period or time frame, then you're going to have to give a bit longer notice, because why are you inspecting? And that's the main question. If it is a renewal inspection, perfect, we expect that, and you will just say, I just want to see how you're maintaining the property before we conclude a further agreement. But the on-the-go inspections, I'm a little worried about, so make sure at the inception of the agreement you agree to that. Otherwise, proper, reasonable notice. And guys, please keep your notice in writing. People forget WhatsApps, so it's important.
Okay, then Silna, another question is, what can a tenant do if a landlord or third party infringes the tenant's right to privacy? Very easy solution. And I do encourage tenants, when you have a landlord that is infringing on your privacy, be it by rocking up at random times, whatever the case might be, not reasonable access. If somebody is coming to maintain the communal property, he's not infringing on your rights. If you are living in a property and the landlord is actually infringing on your rights, the rental housing tribunal is your best bet. Remember, we have the ability to go to the High Court with a spoliation application if you've been deprived of possession. But this is not deprivation of possession per se. It's usually just that constant landlord. You can't turn your back and your landlord's behind you. If it's really an unreasonable situation, approach the tribunal. They will make an order, or at least find out what the story is. Why is the landlord there? If the landlord's there because he's doing maintenance on a regular basis, also a bit of a question there, how necessary is it to do permanent maintenance? But then you can go to the tribunal, and the tribunal will make a very quick order there.
Sorry to derail again.
No, we love it.
You mentioned WhatsApp specifically, and we have an audience question about whether WhatsApp is seen as a sufficient communication method, and can it be held in a legal standing later?
Very good question. It depends on your lease agreement. So in terms of the lease back, we specifically agree that you can communicate in writing by email. I do not like WhatsApp communication per se. If we agree in writing in the lease agreement that communication via WhatsApp would be a recognized form of communication, then most definitely yes. I don't think it's the best idea to have that as your main form of communication. So for your letter of demand, cancellation letters, those things, I prefer to keep that in email. It's easy for us to show to a court that it was actually done, it was actually delivered. A WhatsApp could be your friend that took your phone. I mean, that happens to the best of us. And that's a bit of a problem, but for something like an inspection or arrangements like that, if you arrange that via WhatsApp, it's definitely a valid. And I guess your type of tenants would be WhatsApp people, not email people.
Yeah, like
Yes,
sometimes I would send a lease agreement over email and they won't even get it.
Yeah.
And then I'll just rather WhatsApp the lease agreement and then they get it. They use cam scanner on their phone.
Yes, yeah.
They sign it, they send it back to me on WhatsApp. So I use WhatsApp a lot. And what I like about WhatsApp is the blue ticks.
Yes.
So I can
I
immediately
hate the
see
blue tick and nobody replies.
I can
Don't blue tick
see
me.
that they've received the notice
Yes.
or
Yeah,
that
yes.
they've received
Absolutely,
the communication, and then I know. Versus when I send them an email, I'll have to call them again and say, did you get my
have you
email
got it?
because you
Yeah.
haven't responded in 3 days or whatever. Whereas if I send a WhatsApp and I saw the blue ticks, I know they've received it, and in 3 days or whatever, I can just follow up and say, look, I know you saw this. Please respond. So that
But
makes
do
it
you do
easier
that
for
in
me.
email as well, or do you just record in your lease agreement that you can communicate via WhatsApp?
In my lease agreement,
Good.
I have WhatsApp in there,
Beautiful.
specifically
Yeah.
stipulated. And then I also send the important stuff, like,
Yes.
you guys send the important stuff somewhere directly via email.
Yeah.
So that also,
Yeah.
That's why you're one of my favorite landlords.
Just shows how important it is to have your lease agreement incredibly comprehensive to include everything so that you can communicate these sort of
Yes.
ways. And then also with regards to right of access, so the lease pack clause 16 is the reasonable access clause, which allows the landlord right to access the property on reasonable notice.
Yes.
Now, Silna's also spoken about this, and there isn't really a legal requirement
Yes.
as to what is reasonable. But Albert, what would you regard as reasonable? Have you ever in the past had to give notice to have access to the property? What is your...
Yeah, so I have a property manager that manages all of the properties.
Great.
And she goes in on a regular weekly basis and checks the communal areas. So that's on a continual basis.
Okay.
But if she picks up, there's a weird smell coming from this room, or something's looking dodgy here.
Yes, something.
Or there's some
All sorts of
fumes
wonderful-
coming out of this room or something. Then we do require or
Yes.
send her a WhatsApp to say, look, we're gonna have to inspect, and we also send that to the surety, which also gives us
Okay.
a great opportunity, because the tenant will normally just say no.
Yeah.
Yes.
But when we send it to the mom and says, look, there's some weird stuff happening in your
Yes.
kid's room, we want to go and
I
inspect
mean, that's a
the
message
room.
every mother wants to
Then-
receive.
then-
Overcrowding in your
Then
kids.
she also messages the tenants and what's wrong, what's going on there.
Yeah.
Yeah.
And we had a couple of situations like that where the kid never cleaned his room, and we had to call his dad and say, look, there's not a good smell coming from here. And that happens.
Yeah.
On another situation, I had tenants that Silna helped me to evict, which was basically just not paying rent, and they refused access. And there we had to actually legally draft a letter to request access.
Yeah, that actually leads to the next question.
And get access that way.
Yes, yeah.
But
Yes.
normally it works just with the WhatsApp. Hey, I need to come and check your room. I just want to make sure everything is
Yes.
fine.
Yes.
And you also send it to the surety. Everyone is aware. And then we normally ask them,
Yeah.
when will be an appropriate time this week for me to
Yeah.
come and check?
Yes.
Fantastic. So, I mean, obviously at TPN also we get a lot of queries on this about when tenants refuse access. This could also be relating to marketing the premises to relet, which in terms of clause 39 of the TPN lease pack, I learned all of my clauses just for today. But that allows you to go and market the premises if the lease is coming to an end. But now tenants are refusing access. Silna, what can the agent or the landlord do? You said you helped Albert, yes, I think it's a
Yes,
fantastic
exactly. Well,
example.
we say me, but obviously not me, my lovely team.
Let's give a background here. So the tenant wasn't paying rent, and then I wanted to go put in a prepaid meter because they were running a business at the back of the property, which clearly in the lease agreement states is just for residential use. You can't run a business there. So I wanted to go install a prepaid meter to limit my damages.
Okay.
And we had to request access to do that. And we sent the letters and everything. So we went on the day as communicated through the lawyers, through SSLR. And then when we got there, they literally opened the dogs on us. Came out with sticks and stuff. And luckily we took security with.
Okay.
So that situation was defused. But in essence, we had to leave again, and that was the situation. And now Silma can maybe talk about the legal aspects of that.
What I could have done, to chase that bill up.
but that's basically just one of the instances, and the only instance where I was ever refused access like that in the last 10 years. So I think landlords are also very, what if I can't get access? It doesn't happen that regularly.
Yeah, but what you can do, and this is why I'm saying, instead of chasing up a bill, that's also something that the tribunal is doing much better now. So when was that? That was
2020.
2020, right? So what your options as a landlord either is force access, because the problem is a letter from a lawyer. I don't think it carries the same weight as it used to in the past year. I mean, people get letters of demand and lawyer letters. So often it's like, oh, what if another one? It doesn't carry that much weight. Obviously, for some people, they get a bit of a skrik and they're like, okay. Clearly, in this case, it didn't. It just brings the dogs out. But the thing is, why I said something that could chase up a bill is, I think by now everybody knows me as the lawyer that doesn't want to chase up legal fees unnecessarily. So you can go to the High Court. You can go to the High Court with an urgent application if there is urgency, which the requirement there would be, you will have to show that if you can't get this court order now, you will suffer irreparable harm, which is obviously not the case typically in access. If it's an access issue, for instance, you have a leaking geyser, and the damage that will result from this would be very likely irreparable to the point where it makes no financial sense to let it go. There the court will actually look at it. But my issue with that, and I think I want to caution landlords to make sure you get to the right lawyers that wouldn't end up chasing up a bill, even though that's the correct answer. You can go to the High Court, you can get an urgent application, but it's going to cost you 100,000 rand for that. But you do have access to the tribunal. But before we run to the tribunal, I typically say it depends on why we need access. In a case like yours, where the electricity bill was running away and we had to get access to install the prepaid meter, that would make sense to spend a bit of money, but not 100,000. But fair enough, a few thousand rand to get an order from the tribunal to force access, and a tribunal order carries the same weight as an order from the Madge Court. So you can instruct the sheriff to go with you then to gain access. That makes sense, but very often landlords want access to market the property, especially for sales. Currently we see mid-term sales quite often. And now the tenant doesn't want to allow access. What I advise, and I'm more practical than purely legal very often, is maybe if the lease agreement is anyway running out in a week or two or a month, rather wait it out if the tenant is being difficult, because we can spend the money, we can force the access, but then as soon as you show somebody the property, the tenant's not a happy panda now because we went through litigation. So the tenant is going to say like, anyway, this place sucks and there's rising damp and it's such a cold house, don't know what's wrong here, it's so cold, or whatever, and they cause more problems, and especially for maintenance. To force access for maintenance is very often the worst idea in the world, because the tenant's not a happy camper now about the landlord. So while you are trying to do the painting or whatever, they're interfering or even intentionally causing harm to the maintenance that was just done. So it can be done, but please, 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 landlords, don't try and force access as a matter of principle. That's the quickest way of getting money into your lawyer's pocket with no proper result for you. So think about why we are doing this. It can be done. High Court, Tribunal, Madge Court, wherever, we can get those orders anyway. But does it make financial sense to force that access?
Great, thank you, Silna. Another point we wanted to just go on is obviously maintaining good relationships with tenants, and obviously that results in rental being paid more effectively, encourages renewal of your lease agreement. Albert, can you give any examples of how you maintain your relationships with your tenants how normally when do you normally invoice your tenants? What date do you send out what date do you find the best to send the invoices to the tenants? That was a terrible sentence. Sorry. I got there eventually.
No problem.
But it was.
So my relationship with my tenants is very strict. I have my property manager, which is the good cop, and then I am the bad cop.
Okay.
So I play that role to make sure that the tenants stay on track.
Yeah. Okay.
You almost have to see tenants as people that you have to keep on track. As soon as you start invoicing a day late, or you inquire 3 days late about the rent not being paid, as soon as you start giving leeway, they will take, you give them the pinky, they'll take the hand. So it's almost that kind of relationship where my manager will say, hey, the rent isn't in, please pay quickly, otherwise Albert's going to have to send the next letter, or Albert doesn't play games, he gives it straight to the lawyers, that type of thing. So I will have this dual relationship with the tenant, because if you are just the one landlord and you have to ask the money, but then also be the nice person that's chatting to them, that doesn't always work. Because as soon as you're the guy that's asking the money and doing the invoice, then you have to be strict. So in that case, I have a good cop and a bad cop. And that's how I manage. I manage that payment system to get tenants to pay, etc. And on the first of the month, and then I give them 3 days before I follow up after that, and then continuously follow up until they pay.
And I like what you just said, because to use a rental agent, I see exactly that, because the vetting and everything is obviously different. But it's easier for the agent if the landlord behind the agent is actually very strict and wouldn't give like months and months. The amount of times, Rowan, obviously, in your years at SSL, you've seen this as well. We've seen so many landlords, they give instruction to do a letter of demand. Then the tenant doesn't pay. And the moment we say, okay, cool, we can cancel and commence eviction, the landlord says, sis toch. But they've got kids. And we say, yes, that is very true. That is why they should be paying their rent. Let's commence eviction. And the landlord gives more and more and more time. And I know we want to be nice people, but we can be nice people while we are entitled to payment. And as much as the tenant requires the landlord to perform in terms of the lease agreement, the tenant's not going to say, oh, shame, I've been without electricity for 3 days because the something broke. The tenant's going to be like, now. But
if
then the landlord's entitled to the same.
If the internet just dips a little bit of megabytes for a day, then the phone
instantly.
The internet is done. But to talk about your being friendly to a tenant, right? I see it this way. If the tenant doesn't pay the money, it's not just me that they influence. I am the business owner. I have a couple of properties.
100%.
I have a maintenance team that works on my full-time payroll. I have a construction team that works on my full-time payroll. I have a bakkie, I have the equipment. I have a management team. So if the tenant does not pay, they're not taking away money just from me. They're taking away money from John and More Life and Lynette and Skulk and all these other people that also needs to put food on the table. So for me as a business owner and as a landlord, it's my responsibility to take care of the people that looks to me for income. And I am on the forefront saying that I need to take care of my 5 construction workers. And I need to take care of my maintenance team and my management team, and that's my job. And I need to make sure that the tenants pay so that these people don't lose out. And for a tenant to prioritize their lifestyle and not pay rent in the sacrifice of my team's lifestyle, because now my employee cannot put food on the table because they want to go out and on holiday and not pay rent, that's a problem for me. So I'm very strict and very defensive of my staff and my people when it comes to a tenant not paying. And that's why I'm on it like
Yeah.
this.
And this
The
is
property manager
Yeah.
can be friendly and say, you
Yes.
know what,
Yes,
this, that, this, that.
absoluut.
And you know what, let's sort it out quickly before I have to give it to Albert, because he's
Yeah.
going to hand you over immediately. And when I speak to the tenant, I'm also like, I don't, and then they start giving excuses.
Yeah.
I'm like, I don't care about what your excuse is. If you don't pay within the next
Yeah.
3 days, I'm handing you over. You can talk to Lynette about excuses.
Yeah.
I'm going to hand you over
Absolutely,
immediately.
yeah.
And that's Ubuntu. That's why I'm on about
Yeah.
Ubuntu always in rentals. Thanks,
so
Albert.
I think
Best
if-
Ubuntu story.
I think
There you
if
go.
property investors change their mindset and think about it not just as a tenant paying them, but as a tenant pushing money
Yeah.
into the economy of your business and of your employees and of your loved
Absolutely.
ones, then you'll approach this relationship a little bit differently
Yeah.
between the landlord and the tenant.
Yeah, that's very true.
Absolutely. I mean, also I've had a scenario, actually it was a residential eviction, and the magistrate was quite shocked because the landlord was about 75 years old and this was her one investment property. So that income from the rental was all that she was surviving on. So
Yeah.
you have to consider both parties. Landlords aren't always so evil.
And
They are, yeah,
and tenants
exactly.
don't see it that way. Tenants see it's you that's getting my money.
Yes, yeah.
No, I'm paying water and electricity to keep this
To
thing
keep
going.
you yeah,
I'm
exactly.
paying maintenance to keep this house you're
rates,
staying in
levies,
nice.
everything.
Yeah.
I'm paying employees to make this whole system work. There's
Yes.
bond payments.
Yeah.
There's tax for the property rates. You know,
Yeah.
there's so many things, and I think that's also a very important thing. Whenever a tenant does not pay, my first conversation with them is, okay, so this is my position. I have to pay this to give them an understanding
Yes.
of what's the bigger thing at play here. And then I would always give the tenant 3 options. Like the other day, at one of my properties, one of the tenants had 2 tumble dryers that he recently acquired. Now,
I can see
You see
that
the panic,
I have-
on his face.
I have 44 tenants, right, across 7 different properties, right? So
Yeah.
I can't go and make a deal with him about his tumble dryers,
Yes,
and
yeah.
it's eating up the electricity. So I
Yeah,
went
I'm
down,
sure.
and when I got there, it's excuse after excuse or what, and I just said, look, I'm not here to talk about any. I don't care what you say.
I'm
I don't-
here for the
I
tumble
don't care
dryers.
about any. Here's 3 options, and that's what I always do.
Yes.
I'll never go and force access or force something
Yeah.
on them.
Yes.
I'll always say, okay, so here's 3 options. Option 1 is I raise everyone's rent with 1,000 rand. And then you can
Then
see
the
the other
panic.
tenants
Yeah,
going
I
like,
can imagine.
they're
Yeah.
gonna go steal the tumble dryers.
Why do you want your clothes?
Mob mentality.
So that's the one option. The
Yeah.
other option is I install a prepaid meter for the tumble dryers,
Mm-hmm.
and the third option is we remove the tumble dryers from the premises, and then let them decide.
Yeah.
And that makes
Find it out.
that makes the tenant also feel
Yeah.
like you're
Yes.
not this person that's like boom boom
You're not
boom.
a dictator.
You have
Having there with
your business
options,
to run,
absolutely.
and you're like, here's 3 options. But I'm also
Yeah.
not asking them what do you want to do. I
No.
say, look, 3 options, you choose.
You choose.
Yes.
Exactly. Great. Silna, in your history in the property industry, what are some of the do's and don'ts with regards to maintaining good relationships with tenants?
In my history.
In your history.
The older I get and the longer I'm in this industry, the more I think, oh my goodness, I've been around for a long time now. But no, don't worry, I'll stay. There's going to be more history. Well, the thing is, usually, by the time a matter comes to SSLR for an eviction,
Yeah.
I know for a fact, if I go through the correspondence, the relationship broke probably already prior to commencement of the lease agreement. You can see the lack of communication between landlord and tenant, or everything went well and then something went wrong. And I've seen so many evictions that we do where really the tenant, at the time of conclusion of the agreement, everything was perfectly fine, and something happened in this person's life. They lost their job, they got divorced, whatever. This weird thing like a pandemic hit them. I'm not sure in our lifetime we won't see something like that, but theoretically it could happen. And it rocked their world completely, and they can't afford to pay rent. Then instead of the landlord going with 3 options and having a conversation, the landlord hops onto WhatsApp and starts saying quite a few very nasty things.
Yes.
To the tenant. It's not as encouraging as you think it might be. So it's not always the best idea to do that. definitely take action immediately, but take the drama out of the action. Stick to the true legal things that we need to do. Do your TPN letter of demand. Send him out the next day after the tenant didn't pay. Or if the tenant contravened the conduct rules of a body corporate, do a letter of demand immediately and say, Mr. Tenant, this happened, this was the facts, please make sure next time you don't park on the visitors parking again, or whatever the case might be. But act immediately, but not being dramatic and not threatening. Never, ever, ever threaten another person, ever. I have seen that so many times. The moment a landlord says, well, if you don't do what I want you to do now, I will come and lock you out, or whatever. I know which school your kids go to. I mean, it's bizarre.
It can only get worse from there.
100%.
There's no way that it can get to a good conclusion from there. So
it's irreparable.
Yeah.
So important on that is take the right action and the right steps when you can, because if the tenant didn't pay rent, today is the first, the tenant didn't pay his rent, tomorrow you do a letter of demand. Or already today, do a WhatsApp to say, hey, I see you haven't paid, what's the story? Tenant maybe forgot, whatever. Don't do anything that is not legal and clear, because we anyway need to use those in court later. And you've seen the things we get. Sometimes correspondence come up in court that we, acting on behalf of the landlord, on behalf of the applicant in an eviction, didn't bring to the court's attention. Tenant comes back and says, yeah, but look at the way that the landlord spoke to me.
Yes.
That causes massive problems. Obviously, from the tenant's side, a tenant that maintains a property well, a tenant that pays his rent well, a tenant that reports damage and things to the property as it occurs, that creates beautiful relationships. Remember, people will always be people. Look at my turning to a psychology again. I always do that. The thing is, people are people. And in general, people don't like conflict. And the reason why people get aggressive is because they're actually trying to avoid conflict. They are puffing so much, trying to make this perceived threat go away. So before you puff, take 5 deep breaths. Instead of getting upset and throwing tantrums as the landlord or the tenant, quickly stop, do a polite, clear communication, be it via WhatsApp or email or whatever the case might be. Talk about this, because the truth is people are people, and people don't want to be told what to do. People don't want to feel like they're being accused of something. Have a normal person conversation, and I think that's one of the things that our generation are living through, where communication, we are so used to basically communicating by emojis, right? You can't send a WhatsApp without an emoji to sort of say, I am saying this, but with a friendly face, or I'm very upset. We have to do that. Keep that in mind, and in law and in a relationship between a landlord and tenant, keep in mind that everybody actually just wants to have a pleasant, comfortable, conflict-free relationship. So the more we work towards that, the better. But when you have to take strict action, do it strictly and properly, legally, instead of being demanding and threatening and tantruming.
And if I can maybe just add on to that, Sona mentioned communication in the proper way. Also, quick, clear communication. There's so many times in my experience where you left something and it sort of builds up. And it builds up. And then when you get to the property, the tenant's already furious about this. But there was no communication in between. So it's better to be very strict, very clear in your communication, but also very quick. As soon as something is wrong, immediately communicate it, sort it out right there and then, so that there's no resentment building up, because that can mess up a relationship between a landlord and a tenant. So make sure you avoid any resentment by sorting it out immediately. And I think from a landlord perspective as well, property investment should be a great vehicle to help you empower yourself and build your wealth and become financially independent, or whatever your goal might be. So you have to enjoy the process. Don't make it difficult for yourself.
100%.
In my case, like, I don't like the conflict, like Sona said. So then get proper property lawyers to handle that
conflict.
to handle that for you. I don't want to deal with tenants that don't pay money.
Exactly.
So I speak to them once and then I hand them over. You don't have to fight with your tenant.
Yeah.
And I think that's another thing. Landlords wants to fight with their tenants, and that messes up the relationship even worse.
Yes.
Rather hand it off to the person that can handle it, and you live your best life.
I like that. I really like that.
Property investment should be a joy. It should be something that you love, that you enjoy doing. I mean, you're putting your money, your effort, your blood, sweat and tears into it. And you can structure the way that you manage your tenants so that it does exactly that for you.
Yes, yeah. So just quickly before we go to our Q&A, just on tenants who are breaking body corporate rules, house rules, could a landlord just cancel a lease agreement if a tenant is breaking body corporate rules, house rules, Silna? I mean, I know the answer, but I think everyone else.
I was like, Rowie, how long have you been? How long have you been away from SSLR?
So I also had a situation of, I live in a house share, and one neighbor in our complex was a bit intoxicated one night, and he came through. I don't know why, but decided to look through all of our windows. And my landlord was really upset and wanted to obviously go the eviction route and evict them immediately, which I had to tell him, no, couldn't do that. But what in that scenario can the landlord?
That's a very important one, and now I need everybody to listen up very properly. Okay, so luckily, leaseback users, you guys are safe. We do cater for that, and we do specifically mention that you will attach the conduct rules to the lease agreement. So leaseback users, you are safe. Everybody else, there's an easy way of being safe, but okay, here's the other option. Section 5.8, Section 5 subsection 8 of the Rental Housing Act requires any rules that's relevant to a property, so in your context, your house rules, or in the context of body corporate, your conduct rules, whatever the case might be, to be physically attached to the lease agreement. If it's not physically attached, the enforceability of that is a bit of a problem because the Act requires it to be attached.
Absolutely.
So once it's attached, you have to comply as the tenant with those rules. And if the tenant doesn't comply with that, is in breach, like he would be in any other case. He would be exactly as much in breach as he would be if he doesn't pay his rent. So your action has to be the same.
Yeah.
In terms of Section 14 of the Consumer Protection Act, you need to give 20 business days notice to remedy the breach. And if it comes to something like breach of conduct rules, you're going to say, hi, Mr. Tenant, you keep on parking on the visitors' parking. Or you're drunk and you're looking through the windows. You know, I mean, that's weird. You're not allowed to do this. In terms of this rule of the conduct rules attached
you're mining
to the agreement.
on the internet.
Exactly. And you need to remedy your breach in 20 business days. But I mean, you can stop looking through windows right now and then do it again afterwards. So the letter that you're going to use is not the standard, for instance, TPN letter of demand. That's where you pick up the phone, you go to your favorite law firm, and then do a letter of demand that, to specifically say, if you stop doing this now, fabulous, but if you do it again, we're going to cancel immediately and then we're going to evict you. But it's the content of the letter that is absolutely essential. Then you would be able to cancel, but you can't ever cancel with immediate effect. In terms of the leaseback, the only times we can cancel immediately is obviously in the context of criminal activity in the property, which is really dangerous. We need to do that immediately. Or in the case where a contract wasn't properly formed, for instance, fraudulent activity during the application process. Other than that, you can never, ever, 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 ever cancel a lease agreement immediately. And you can commence eviction as soon as the lease agreement's been cancelled. And remember, when we say eviction, guys, keep in mind, we always mean eviction through a court. Eviction can never mean a lockout or whatever.
Absolutely.
But getting tenants to stick with the rules, the best way to do that is to choose the right tenant in the first place.
100%.
I've learned that over the years. You can put any tenant in and then you have to fight with them to stick by the rules. Or if you choose your tenants very, very carefully, you never have a problem. So it's I like to be able to present the tenant with the rules, say, look, this is the rules, and then see how they respond and meet them in person.
Yes.
So many landlords have someone else placing tenants that they never even see, and there's no quality control on that. And then you struggle with tenants not keeping to the rules.
Yeah.
But if you have a good, proper tenant, then you might not even ever have to worry about them breaking the rules because they are good tenants. And I think that's also the basis of a good relationship is
100%.
choosing a good person to have that relationship with.
Exactly.
Yeah.
And weirdly enough, our next webinar is actually on choosing the right tenant and vetting the correct tenant, which is on the 5th of July. Am I correct, Nikki?
Yes.
Yeah, 5th of July. So perfect ending to that. Thank you very much. Guys, we're going to go to our Q&A now. Nikki, do you have the winners of the book?
Yes, I do. Sorry, you've just put me on the spot. Maybe I
Sorry.
can give you a question.
Yeah,
in
let's
the
do a question
meantime.
first and then we'll do the winners.
Sorry, I was expecting that as well.
Nikki was enjoying the story from all
There are a lot of people with tenants not doing as stipulated in the lease. For example, they need to upkeep their swimming pool or make sure whatever. And they're asking what they can actually do to remedy that. I know you've just said now you can send the letter of demand. Does that apply to all maintenance issues?
Yes. So absolutely anything that a tenant has to do in terms of the lease agreement, not anything the tenant has to do which the landlord sort of feels he should, but it's not part of the lease agreement. Anything in the lease agreement. That's why if you look at clause 17 of the lease pack, it's 17.1 is the tenant must do a million things. Not a million, close to. And
Quite
the
a few.
tenant must not a lot of things. For instance, this week, I've had quite a few questions on my WhatsApp groups. I don't know why, it's always these themes.
Yes, yeah.
And this week is the insurance theme, weirdly. And for instance, the one tenant is not doing the right things to allow certain maintenance to be done, which is now currently affecting the insurance policy. And even things like that. So that's not even the swimming pool. It's even you are bringing things onto the property that is going to affect the landlord's ability to claim for a burglary or whatever, or for damage to the property. If those things are happening, not cleaning a swimming pool, not keeping the gutters clean, whatever the case might be, as long as it's in your lease agreement and the tenant is not doing that, you're going to do a letter of demand 20 business days in the context of a natural person lease agreement. And if the tenant doesn't fix it in that time period, you can cancel. And commence eviction.
Fantastic.
We have another question on a very similar thing. It says, if you cannot get access due to the current tenant and you need to show your next potential tenant the property, can it affect that current tenant's deposit?
It can actually. Okay, so where that would happen is only in the context of if the lease agreement was anyway supposed to end, everybody knew about it and you're supposed to show the property. In a case like that, where the tenant now refused the landlord to show the property to other people, it means the tenant is causing, but now this is not a contractual thing, this is a delictual claim. On a delictual level, now the tenant is limiting the landlord's ability to place a new tenant. So the landlord is going to suffer financial loss because of the tenant's failure to allow access, most definitely. But don't just sit and be like, I'm not going to do anything, I'm going to take your deposit. Very stern letter to say, if you do not allow me access to the property, I can't show the property to prospective tenants, and any financial loss that I'm going to suffer, I will be deducting from your deposit. Then you would be able to do that. But please don't cowboy that one and just hold on to the deposit. Do the proper notices in time, in enough time for the tenant to be able to allow access and for you to find a new tenant.
Absolutely.
Okay, I have your two winners.
Fantastic. Very good.
It's been in my inbox for a while. They were picked randomly. It's Karen Hellberg and Marie LaRue.
Fantastic. Well, congratulations to you guys. You'll be receiving your books quite shortly.
Which ones are they getting? How to Buy Your Happiness?
Karen is getting How to Buy Your Happiness, and Marie will get How to Become a Millionaire at 22.
Are you going to love it?
Yeah. I hope you're 20 or 21.
Well, it's not. It's
No,
for any
I'm
age.
just
So you're going to enjoy it so much. And be
Fantastic
sure
books.
to Instagram me and tell me how the book was. I would love to get your feedback.
And enjoy
Awesome.
buying your happiness.
Yes.
Look at that.
Fantastic. Any more?
We've actually got some interesting conversations on here. One person was mentioning that their tenant has a lot of snakes and spiders as pets, and they were getting complaints about the smell. Would that be stipulated on your lease agreement as pets? I mean, they're not your typical dog or cat.
But you should, and that's exactly why, in terms of the lease back, where we complete pets, we say number of pets and details.
Yes.
We need to know, because a bird, for instance, a lot of people don't really see a bird necessarily as a pet, but I don't know what else it is then. It's not a decoration, it's a pet. It's
a
very
pet.
much a pet. Or cats, for instance, whatever the situation is, you do need to specify that. And especially stuff that lives in terrariums. Is
Yes.
that
Well done.
I'm so proud. Like snakes, all those things. It can cause a massive safety risk as well in the property because of the lights and everything, and it could, it smells funky. So it's definitely something that the landlord has to consent to, as in the case of a dog or a cat or whatever.
And you get used to these type of things with experience. So as you have a lot of tenants, you see the funny things that they bring onto the property.
Yeah.
And, I start writing them into the lease agreement. For example, some of the tenants did Bitcoin mining, on my electricity bill and internet bill. So then
and it's not currently even helping them at all.
In the next lease agreement, you say, no Bitcoin mining or no spiders, and you literally put them out there. No planting illegal substances in the garden. I mean, that's also a thing that happens.
Very important one to include.
So,
Very important.
As you gain experience, you as a property investor or as a landlord, you'll start noticing all of these different things, and with a few iterations, you'll have a lease agreement that takes care of all of this.
Yes.
Because you've learned from experience that these things happen.
Yeah,
absolutely.
We've got quite a few questions about who is responsible for which maintenance in the property.
I can do that one very quickly.
Okay.
There we go.
Okay, I'll be very quick. I'm going to do this in a few seconds. Landlords and tenants both want a list. These items in the property, the geyser, the gate motor, the stove, is landlord's responsibility. Everything else, tenant responsibility. Or the other one that people believe is outside landlord's responsibility, inside tenant responsibility. Yellow. There isn't a list. There isn't a standard rule, but there is. But it's not item standard. It is event standard. So it's very simple. Fair wear and tear maintenance must always be done by the landlord. In terms of the lease back, again, we define fair wear and tear. Fair wear and tear is damage or wear on an item or a thing during during time. It happens. Paint will fade after a bit. What. Anything that breaks intentionally or accidentally by the tenant during the subsistence of the lease is for the tenant's responsibility. Yeah. So fair wear and tear, landlord, on-the-go maintenance, short-term consumables for the tenant.
Yes.
So the same swimming pool pump today that is old, that must be replaced, the landlord must replace him. The swimming pool pump that died because the tenant let him run too much or too often or not at all, now it breaks, now the tenant has to replace that exact same swimming pool pump.
Yeah. And maybe I can add in here, a lot of landlords, when they start with their first property investment, they try to please the tenant very, very often. So when the tenant says, there's a little leak on the carport, then they immediately go and fix it.
Yeah.
And, I think my door needs new paint, then the landlord immediately goes and fixes it because they want to please the tenant.
Yes.
And that's also the wrong way to go about it. And I think a lot of first-time property investors fall into that trap because they think if they keep on pleasing the tenant will be happier and then they will pay the rent on time.
Yeah.
That is not true. Okay, a tenant will never like your house because it's your house.
Yeah.
They would have liked if the toilet was here, or if the
Yes.
stove was there, or if they had this ferning or that door. So, as I said in the beginning of this interview, you have to train your tenant.
Yes.
So when a tenant comes to me and say, this tree is putting stuff on the floor in front of my
Yeah.
property, would you please come and remove it? Then I don't do that immediately.
Yeah.
And maybe I don't do that at all.
Yeah.
Just so that the tenant understand that I'm not there doing everything they ask for, because at some stage that becomes a point where you become the tenant's slave
Yes.
in a sense.
Yeah.
Because now everything, oh, this is dirty, oh, this needs to be repainted, oh, this is...
Yeah.
And that becomes a problem.
Absolutely.
So make sure you attend to the real big things, like if the geyser bursts or if
Yeah.
the toilet overflows, and there you're immediately there, you sort it out. But the other things, manage the tenant in such a way that they get used to what they can ask you for
Yeah.
and what they shouldn't.
Yes.
Fantastic. Great. Well, Silna, Albert, thank you so much for coming and joining us today and giving us your expert advice. It's been fantastic. Everyone, we have just run out of time. So if you have any questions, please send it through to legal@tpn.co.za as well as helpdesk@tpn.co.za, and we are more than happy to help. Thank you, everybody. Have a great weekend.
Thanks, everyone.